Thank you so much for the kind words of introduction, and now I really feel like the pressure is on me to try to address the serious questions that are the topic for today. I also want to thank Vice Chancellor Kumar for inviting me to make this first visit, and I promise it's only the first visit, I will make more, to this wonderful Jindal Global Law School to deliver this special lecture. I'm really, really honored to be able to participate in this event, especially because of the presence of Justice Mittal from the High Court and Mr. Parija from the Bar Council, and all of the many other distinguished guests who are with us here tonight. And I'd also like to thank very specially my own colleague, Professor Krishnan from Indiana University's Maurer School of Law, who worked tirelessly over weeks and months with Vice Chancellor Kumar and with many others at the OP Jindal Global University and at Indiana University as well to make this ceremony a possibility. I can say with certainty that this is definitely an evening that I will long remember. So thank you all. The topic for my talk this evening is the future of the death penalty in the United States and the world. In recent years, the death penalty has become, once again, a subject of great interest and great controversy around the world. In the United States, we continue to debate whether the death penalty should remain a part of our criminal justice system. I know that here in India, a similar debate is taking place, and I also know that the Indian courts and the Indian people are currently grappling with the most serious questions about the need for and the justice of capital punishment, and you heard about that from Justice Mittal just a few minutes ago. During the nearly 3 decades that I have been studying the death penalty, one thing I've learned above all else is that there are no simple answers to these questions. The death penalty, because of its unique and awesome impact, and because of its irrevocability, requires each and every one of us to think in the most careful way about the most fundamental issues of justice, fairness, and the needs and the interests of society. The death penalty will always be controversial, and that is how it should be. Indeed, it is how it must be. In any democratic society, the death penalty must always be viewed as a matter deserving of the most serious public deliberation and debate. I once gave a public lecture in Japan in which I explained that the death penalty in America will never be administered in a manner that is quick and inexpensive. That is not a sign of weakness. Instead, it is a sign of a society that cares deeply about fairness and justice, and that also recognizes that no human being is infallible, including the government officials and the lay jurors who, in America, bear the responsibility for finding a defendant guilty of a capital crime and imposing the ultimate punishment. Capital cases represent, in a sense, both the best and the worst of our legal system. It can be the worst when our emotions get the better of us and cause us to make decisions based on simple vengeance or the public's demand for closure. But capital cases also can bring out the best of the legal system, precisely because there can be no room for compromise when it comes to the administration of justice in a capital case. Capital cases generate much more litigation than most other criminal cases because almost everyone would agree that when a defendant's life is on the line, the desire for perfect justice is at its greatest. And this necessarily generates many legal issues on which the appropriate balancing of interests often seems too close to call. This is why I believe it is futile and foolish to make confident predictions about the future of the death penalty. Too many times I have seen experts in America make simplistic predictions such as the death penalty will soon be abolished in the US, or going in the opposite direction, now that the Supreme Court of the United States has decided the such and such case, removing a particular legal barrier to the death penalty, we will see a dramatic increase in executions. These predictions in both directions never prove true because the political, social, cultural, religious, and legal dynamics of the death penalty are far too complex for any such simple analysis. Another kind of expert prediction has become rather popular in recent years. This is the prediction made by numerous academics that we are witnessing, or will soon witness, a worldwide harmonic convergence of moral values against the death penalty. This harmonic convergence supposedly will lead in an inexorable fashion to the worldwide abolition of capital punishment. Some experts allow for the possible exception of China and several of the Islamic states. But the predictions generally hold that with the possible exception of a few outliers and rogue states, the death penalty will, in the foreseeable future, become viewed as a universal moral evil and will therefore become totally obsolete, a thing of the past. Now, as a normative matter, or perhaps as an article of faith, I have no particular quarrel with those who assert that the death penalty must be abolished as a moral evil. Nor do I have a quarrel with those who argue similarly for retention of the death penalty on normative grounds. These are normative moral questions upon which reasonable minds may differ, and each person is certainly entitled to his or her own opinion. But as an empirical matter, I find such predictions of worldwide harmonic convergence toward a utopian normative view against the morality of the death penalty and resulting worldwide abolition hard to take seriously. The future of the death penalty worldwide is subject to the same complicated and unpredictable matrix of political, social, cultural, religious, and legal dynamics that have long affected the issue domestically in the United States. Simply put, it seems to me virtually impossible for anyone to know, as an empirical matter, precisely what the future of the death penalty will be, either in the US or in the world. Thus, the theme for my lecture is the limits of harmonic convergence. And here I will make my own, perhaps not quite so bold prediction. I would predict that the future of the death penalty in the United States and elsewhere around the world will depend not so much on universal views about morality or human rights, but instead on wide variations in local conditions, political, social, cultural, religious, and legal, that will continue to produce unpredictable and inconsistent results. Now, in one limited sense, those who predict worldwide abolition of the death penalty on moral grounds ultimately, in some distant future, will see at least part of their prediction come true. Abolition tends to be a one-way ratchet, as we say. Once a particular society has gone through the trauma, the controversy, the turmoil of abolishing the death penalty, it is extremely rare for that decision ever to be reversed. Only the most extreme kind of heinous crime, one that leads to a new or resurgent society-wide demand for ultimate retribution, is ever likely to lead to the reinstitution of a death penalty after it has been abolished. In this limited sense, one might therefore say that there will be a kind of inevitable convergence over the long haul at some distant future in the direction of abolition. But the notion that societies around the world will come together in the foreseeable future, or indeed, as some assert, are now coming together today, around a shared set of normative values that render the death penalty inherently unjust and that will lead to worldwide abolition of the death penalty, seems to me to be an example of wishful thinking by those who would like to see that happen. To put it more simply, death penalty abolition stories, whenever and wherever they occur, are as varied as the societies and cultures from which they originate. This is true even in a single nation, federal nation like the United States, and it's even more true when one considers very different nations around the world. If advocates of harmonic convergence against the death penalty have any sound empirical basis for the claim, it must rest largely in the fact that over the last century, European nations have turned completely against the death penalty. England was an early adopter here, effectively abolishing the death penalty in 1957, although the formal decision didn't occur until some years later. As I'm sure many of you know, England abolished the death penalty in large part due to 3 controversial capital cases during the 1950s, illustrating the point that local conditions on the ground invariably influence decisions about the future of capital punishment. The first of these 3 infamous cases was the Bentley-Craig case. In 1952, a London police officer was killed in a shootout attempting to arrest 2 young men who had broken into a warehouse. The youths were Christopher Craig, who was age 16, and Derek Bentley, who was age 19. The evidence showed that the younger man, Craig, was the actual killer of the police officer. However, and it also showed that Bentley was mentally impaired and went along with the crime, mostly because he was acting under the influence of the younger Craig. But Bentley received the death penalty and was hanged, while Craig, the more culpable of the 2, avoided the death penalty simply because he was under the minimum age. It was written at the time that seldom has any execution caused so much controversy and public concern or such scenes of public emotion. The second case in England was the Evans Christie case, in which an innocent man was executed for a murder that was actually committed by another. And the third case, perhaps most reflective of peculiarly English norms, was the case of Ruth Ellis, a young and attractive woman who was hanged despite the pleas of thousands of English that simply by virtue of being a young and beautiful woman, she should be spared execution. Taken together, these 3 cases became the catalyst for the abolition of the death penalty in England. Now today, as a practical matter, all of the nations of Western Europe have gotten rid of the death penalty. Moreover, abolition of capital punishment has been made a virtual condition for admission to the European Union. And as the EU spreads eastward, this has led to a recent wave of abolition decisions among members of the former Soviet Union or Soviet bloc. Whether these recent decisions are evidence of spreading moral consensus or instead evidence of the strong desire to join the EU is unclear. Moreover, whether abolition across Europe is a harbinger of worldwide harmonic convergence or merely an example of political and social and cultural integration within Europe remains to be seen. Personally, I tend to favor the latter interpretation. The evidence seems to me to suggest that European nations, so often unable to come together around various issues of social or economic concern, are happy, delighted to have found at least one issue, capital punishment, on which they can all agree, especially when that agreement allows Europeans to take the moral high ground in dealing with the United States and other countries as well. The spectacle of Italian public celebrations whenever an American death row inmate avoids execution is one example of this rather odd phenomenon. Let me take a few minutes to describe to you the current state of the death penalty in the United States. And actually, I'm going to add to my remarks just a couple of words in response to the questions raised by Justice Mittal. So in the United States, as you may well know, we did in fact have a brief period of what you might call legal abolition. In 1972, the US Supreme Court held, in a famous case called Furman, that all death penalty provisions then in existence in the United States were unconstitutional. However, the Supreme Court left open the possibility that a new kind of death penalty statute might be written that would pass muster under the Constitution. And 4 years later, in another famous case called Gregg, the US Supreme Court held that this new kind of death penalty statute, in fact, was constitutional and death penalties could resume. The new kind of statute was based on the principle of guided discretion. In the United States, all capital sentencing is performed by a jury rather than by a judge unless the defendant waives that right. And guided discretion was designed to give the jury some guidance in making its death sentencing decision, while at the same time leaving the jury with some discretion. The guidance comes from a set of rules. The rules are called aggravating circumstances, which argue in favor of the death penalty, and mitigating circumstances, which argue against the imposition of the death penalty. The jury will be told in every capital case that it must make findings, factual findings, about the existence of these aggravating circumstances and mitigating circumstances. And the jury is then told that it should weigh those circumstances against each other in deciding whether or not the death penalty should be imposed. At the same time, the jury is told that these factors do not completely determine the outcome. The jury retains discretion to do what it thinks is morally justified. As Professor Robert Weisberg argued in a very, very wise law review article many years ago, the decision about whether to sentence someone to death is not so much a legal decision, it is not so much a matter of simply applying legal rules, as it is a matter of fundamentally moral judgment. One does not look into the law books as much as one looks into one's own heart when deciding whether a person deserves to live or to die. So in that sense, Justice Mittal, I'm sorry, I cannot give you a legal answer to that question. It's a fundamentally moral judgment. That is why in the United States, juries are left making that decision, and that is why they are given discretion, although it is guided discretion. The role of the courts has been primarily twofold. Number one, our courts have imposed a very strict and elaborate set of special procedural rules that guide the handling of a death penalty case. These rules are referred to as super due process, going beyond the due process that applies in any criminal case. And secondly, our courts have imposed certain rules under the Eighth Amendment, which prohibits cruel and unusual punishment. These rules are based on the principle of proportionality. Our Supreme Court has held that there are certain kinds of crimes and certain kinds of criminals for whom the death penalty would be a disproportionate punishment and therefore unconstitutional under the Eighth Amendment. That is why in America today the death penalty can be imposed only for murders and possibly treason or espionage, although we don't even know the answer to that for sure. Certainly murders are the main reason why people are sentenced to death today, and it's also the reason why in America today the Supreme Court has excluded from the death penalty juvenile murderers and persons who are mentally retarded. They cannot receive the death penalty. In the United States today, we are quite far from national abolition, although 4 states, New York, New Jersey, New Mexico, and Illinois, have abolished the death penalty in recent years. Still, nearly 2/3 of the American states have capital punishment in their law books, and almost half of the states continue to carry out the ultimate punishment, at least on occasion. In 2011, there were 43 executions in 13 states. This number was down slightly from the annual total of 46 executions in 2010 and 52 executions in 2009, but slightly higher than in the 2 preceding years. And public support for the death penalty remains strong at more than 2 out of 3 Americans. Moreover, I can assure you with complete confidence that if Mohammed Atta or any of the other terrorists who carried out the September 11th attacks in New York City had survived to stand trial, American public support for the death penalty would be much higher than that. Support for capital punishment in the US today is based primarily on the retributive view that there are some extremely heinous murders, our Supreme Court refers to them as the worst of the worst, for which only the death penalty can properly express society's moral outrage. Even if the death penalty does not deter crime, and the strongest evidence is that it does not, most Americans continue to believe the death penalty to be morally justified in at least those very rare cases. Now, in the US, the primary moral arguments against the death penalty, or in favor of abolition of the death penalty, haven't changed very much at all. Those arguments are the sanctity of human life, the immorality of state killing, and the possibility of racial and socioeconomic disparity in the imposition of the death penalty. These arguments are the same arguments that have been made for decades. And whatever their force may be, they have made relatively little progress in changing the balance of public opinion in the United States. Occasionally, a political leader or a member of the judiciary may become persuaded by these kinds of arguments and may change his or her own personal position on the basis of moral arguments of this kind. But as a matter of society, these arguments do not seem to make very much difference. Just as an aside, a few years ago, I heard a very different kind of moral argument against the death penalty, one that actually came from what one might describe as a more conservative point of view. At my invitation, a former Japanese Supreme Court justice named Shigemitsu Dondo gave a major lecture at our law school in Indiana. And in that lecture, Justice Dondo, who is, by the way, he is the most prominent and most widely read abolitionist figure in Japan today, he made the following argument. He said, people who support the death penalty often base their view on the notion of free will. It's an inherent part of the retributive argument for capital punishment. Namely, the belief that every person has free will and is responsible personally for their own choices, including the choice to commit a very heinous crime. And they cannot hide behind or be excused by their past, by the way they were brought up, or by their past history. Now, Justice Dondo said, if that is true, then it must also be true that no person who commits a capital crime is a prisoner of his own past. In other words, the death penalty is a rejection of free will and the possibility that no matter what, a person can still change. The death penalty, in short, argued Justice Dondo, represents the denial of the strong belief in free will because it effectively eliminates the possibility of future change for the condemned individual. Now, this is a very powerful argument, it seems to me, but like most moral arguments, This argument, too, proved incapable of persuading those who had already committed themselves to a different moral point of view about the death penalty. Moral arguments, in short, tend to appeal primarily to those who already share the same moral point of view. And that is why in America today, the debate about capital punishment has largely shifted to a very different kind of argument, or at least several different kinds of arguments. I will just briefly mention those arguments to you now. In America today, the arguments that have the most impact on the death penalty debate are as follows. First, the possibility, indeed perhaps even the likelihood, that someday a mistake will be made. In Illinois, around the year 2000, it became known that there were at least 13 people on death row who were in fact innocent of the crimes for which they had been convicted and sent to death row. This argument about the risk of error leads to a related argument, a kind of conservative argument, that says, what do you expect from a government program? Columnist George Will, a noted American conservative, wrote, "When did we forget that the death penalty is just one more example of a failed government program?" This kind of anti-government rhetoric has really shifted the terms of the death penalty debate in America today. A third related argument is the economics of the death penalty. If there are problems with the death penalty, if the death penalty runs the risk of a grievous error, mistaken execution, if we need to fix the system because it's broken, that's going to be very expensive. And in today's world, perhaps we cannot afford that kind of expense, and therefore cost itself becomes an argument against the death penalty. Politicians hate to be soft on crime, but they hate even more raising people's taxes. And finally, what we saw in Illinois after the revelations about innocent persons on death row is the problem of a kind of political stalemate that prevented Illinois from even considering adopting serious reforms of the death penalty. And what happened then is that after a period of 10 years in which no executions took place in Illinois, we ended up with a death penalty that was functionally abolished, even though not legally abolished. And at a certain point, after such virtual abolition persists for long enough, the people finally say, why do we bother? Why are we still spending money on capital trials if no one's going to be executed? And that eventually led Illinois to pull the plug and abolish the death penalty entirely. Now you might ask, what role does international law, or international opinion for that matter, play in all of this debate in the United States? And the answer, unfortunately, is very little. The U.S. Supreme Court has rarely been influenced by international norms or by international law, although in the juvenile death penalty case, Roper v. Simmons, the Supreme Court did cite the brief of the European Union. More typical of the U.S. reaction is the Medellin case a couple of years ago, in which the Supreme Court flatly rejected the argument that the states must comply with an international treaty signed by the U.S. that required people charged with a capital crime to have access to their own national consulates. Now these arguments, innocence, anti-government, economics, virtual abolition, they interact in many different ways. In the US, as a result, if there is such a thing as an abolition movement, it proceeds in fits and starts. You can contrast Illinois, which eventually, finally pulled the plug on the death penalty, with Texas, where there's no sign at all of movement in the abolition direction. Elsewhere around the world, the situation is similarly varied. I'll just briefly mention, in the interest of time, some of the countries that are still debating this question. In Japan, the death penalty became a significant part of their modern legal system in large measure because of their strong ties with the United States right after World War II, which helped underpin traditional Japanese pro-death penalty attitudes. At the same time, Japan is very much concerned about how it looks to the rest of the world, and therefore international influence, which is irrelevant in the US, plays a significant role in Japan. In Korea, the death penalty is caught up primarily in domestic politics. But, interestingly, the Koreans are well aware of the fact that if they abolish the death penalty before Japan does, they will get a leg up on their traditional rival. In Taiwan, the issue of the death penalty is closely connected to the issue of innocence and the fact that Taiwanese people at present are very concerned about flaws in their criminal justice system generally that can lead to the conviction of innocent persons. In China, of course, the death penalty continues to be used widely as an instrument of state control. Last but certainly not least, here in India, you have something very similar to the de facto moratorium, the virtual abolition or functional abolition that we saw in Illinois just a few years ago. At the same time, it seems that the Indian judiciary has no strong desire to provoke a public backlash by ruling against the death penalty, and in this way, it looks a lot like the US. Just a couple of years ago, in a very remarkable case called Bays against Rees, Justice Stevens on the US Supreme Court expressed the view that in his opinion the death penalty was immoral and unconstitutional, but at the same time he declined to vote for that position because he said it wasn't something that the Supreme Court should do. Instead, he said that state legislatures should reconsider the issue themselves. It's actually quite a remarkable and unusual opinion by Justice Stevens and well worth reading. I'll also point out, for what it's worth, that Justice Breyer, in a case called Knight against Florida in 1999, actually cited a decision by a court of India. On what question? On the question of whether extreme delay in carrying out the death penalty should be viewed as a possible argument for the unconstitutionality of the death sentence. Justice Breyer cited an Indian court opinion on that question. Our Supreme Court has not, by the way, actually taken up that question. Justice Breyer cited the Indian decision in an opinion in which he argued that the Supreme Court should take up that question. Well, in conclusion, my goal today is really rather modest. I hope that I've persuaded you to think very carefully before accepting at face value the claim that we are presently witnessing a worldwide harmonic convergence of norms and values in which people around the world are turning against the death penalty because of a shared view that capital punishment is a moral evil. Except in Europe and a few other places, including South Africa, I see little evidence of such a worldwide moral or normative consensus. What I do see is that societies around the world continue to grapple with the issue of the death penalty in terms of their uniquely local contexts of politics, economics, and law. The issue is simply too complicated to be resolved by a simple solution. And the possible paths to abolition, if and when it ever occurs in a particular jurisdiction, are many. I look forward to your comments and your questions. Thank you.